Welcome everybody to International Trade Live. My name's Joseph Clark and I'm the editor of International Trade magazine. In this interview session, I'm joined by international arbitration expert Aoife Keane, who is a partner at law firm Ontier UK and who will be discussing the importance of international arbitration for those working in international trade. Aoife, could we begin by you explaining a little bit about what international arbitration is and also how does it differ from litigation?
Sure. Thank you, Joseph. So international arbitration is a private means of parties resolving their disputes. It's where parties choose to resolve their disputes in a different forum from the courts of a national country, and rather to resolve it under rules that they choose themselves with an arbitrator or arbitrators that they have chosen themselves. And they really decide between themselves what rules will apply and what procedures will apply. And for parties from different jurisdictions, as you will have in supply chains globally, it's very important for them that they can find a private means of resolving disputes that don't rely on the nation states of one of the parties' courts. They want to have a neutral forum to resolve any disputes that arise in the context of their agreements.
And what are the principal advantages then to international arbitration over litigation?
Well, certainly in the international trade context, there are many advantages. And the first I would say is the advantage of territorial neutrality. So if you have one contracting party who's based in the UK and one who's based in Romania, if they have a dispute down the line in relation to some part of the supply chain or some part of the logistics side of things, neither party is going to want to resolve that in the courts of the other party. They want some neutral forum, and more importantly, they also want the chance to be able to choose who is going to resolve my dispute. Do I want an English judge who may not know the intricacies of, let's say, supplying iron ore, or do I want an expert in that area? The arbitrators can be chosen by the parties so that they can choose parties that have that expertise. They can also choose the rules that decide where they're going to have the hearings, when hearings are needed, how many arbitrators, what are the timelines for putting in their submissions, expert evidence, etc. So it really allows international parties to have a neutral forum that they have chosen themselves. And that is seen as one of the major advantages. Another advantage is confidentiality. Parties love confidentiality when they have a dispute because they don't necessarily want to have bad publicity throughout globally in the export market industry in relation to what has gone wrong. So with arbitration, you've got that confidentiality between the parties. And there's also the ability to decide between themselves how matters progress. And none of this ever has to come out in mainstream media. So it won't affect other suppliers or distributors along the line who think, oh, well, they've got a problem. They've just, something has gone wrong in their logistics side. It never needs to come out. And for many parties in international trade, that's very important to them.
And regarding when this type of agreement could be applied, can an arbitration agreement be included in any commercial contract?
Absolutely. In any commercial contract, which is an agreement essentially between two contracting parties or more, they decide what terms are agreed between them, and they can decide that they would like to arbitrate rather than litigate in the courts of any jurisdiction. The main point is that the parties must agree. Arbitration is a consensual process between parties, and if the parties say, let's take our dispute outside the realms of the national courts, let's take it to a private forum where we can arbitrate rather than litigate, all they need to do is vary their agreement, if that clause doesn't exist there already, to say that they have agreed that arbitration will be the means by which they will resolve their dispute, and that can be incorporated into their agreement. So any agreement can have an arbitration clause.
Okay, and what is the difference between institutional arbitration and ad hoc arbitration?
So institutional arbitration is arbitration under the rules of a specific institution, and there are many institutions that run arbitrations. Some of the best known are, for example, the LCIA, which is the London Court of International Arbitration, the ICC, which is the International Chamber of Commerce, Singapore International Arbitration Centre, Hong Kong International Arbitration Centre. There are many, and all of these institutions have their own rules and procedures that the parties will follow if those rules have been incorporated into their agreement. So typically in the clause that you would find the agreement to arbitrate, it will say which rules apply if institutional rules are intended to apply, and that will govern the whole procedure. It will also state how many arbitrators, what the seat is, and I can talk about that a little bit later, etc. But under institutional rules, the good thing for the parties is they don't have to agree on every single thing because there are rules in place. Ad hoc arbitration, on the other hand, simply provides that the parties will arbitrate, but not under any particular institutional rules. And in that case, the parties need to agree on everything from how the arbitration tribunal, as in the arbitrators, are nominated and appointed, down to how the pleadings are submitted, timelines for all the steps that are required, etc. So ad hoc is probably a lot more challenging for parties, and parties generally will choose to use some institutional rules.
You've just mentioned that once the two parties have agreed upon the agreement to take, what is the role of the arbitral tribunal, and how are the arbitrators appointed?
So that's very interesting, Joseph. So once the parties have agreed to arbitrate if any disputes arise, they will say in their agreement to arbitrate, which is the clause in their agreement, how they would like to appoint the arbitrators. Now, usually you will have either one, a sole arbitrator, which might be better for a lower value dispute, or a three-person panel, essentially. And in the case of a three-person panel, what usually is provided for is that each party chooses one of the arbitrators, and then those two arbitrators choose the third, who will be the chairperson of the tribunal. Now, this allows parties, especially in the context of international cross-border agreements and in the international trade arena, to choose one arbitrator each, and they can choose a party that they know has expertise in exactly the area that is in dispute. And that is very important to parties. They do not have to be legally trained. Many of them will sit as arbitrators in many proceedings, and they will have legal training, but they do not have to be. They have to be experts in their area, and the parties know that they're getting somebody who's adjudicating their dispute who actually knows what they're talking about. In the case of a sole arbitrator, the parties have to agree on who that person will be. So usually what happens is one party will say, I like X, Y, and Z, and give three names to the other party. The other party will come back and say, well, we can agree to X, but not Y, or we propose these people. It's an over and back process. Eventually, the parties will find the right person. And if they don't, they can always apply to the governing body or the institution if they're using institutional rules, or otherwise to the Chartered Institute of Arbitrators. But generally speaking, that won't happen. The parties will agree on who that arbitrator should be, because there are a pool, they're specialists in their areas, and the lawyers and the parties will eventually reach the right decision.
It sounds like there's quite a lot of flexibility then from what you're saying.
Absolutely. And it's one of the parts of international arbitration that I think parties and their legal representatives find extremely liberating, because obviously when you're in the courts, you have an assigned judge. You have no choice about that. You have timelines that you must follow and sanctions that follow if you don't follow those timelines. But this process is all about consensual agreement between the parties.
And moving on then to the process itself, how does that take shape from filing a claim to the final reward, so to speak?
Sure. So, I mean, usually the process is kicked off by a claimant who has a claim, essentially by filing either a notice of arbitration or a request for arbitration. It depends on the rules, and I'm speaking about institutional rules at the moment. With ad hoc, the parties must agree to everything, so that's slightly separate. But if the parties have decided that they will follow, say, the rules of the International Chamber of Commerce or the rules of the London Court of International Arbitration, they will follow those rules, which will say a request must be filed, and within X days, a response must be filed by the respondent, which is the other party to the arbitration. And in that, they will agree according to the rules on who should be the arbitrator or the arbitrators, and the process is kick-started like that. And what follows once there has been a request and a response by the parties are the stages that are typical in any kind of a litigation dispute. They just happen on a much more consensual timeline than if you're in the courts of a national state. So how it usually happens is that the parties will file what's known as pleadings or statements of claim, setting out the basis of their claim. The other side will put in their defense or their response to this. And after that, there will be witness statements by any pertinent witnesses, and they will be filed by either side. There may be document production, but this is generally a lot more limited than in court processes, where it can be extremely costly, extremely time-consuming, and ultimately probably not as beneficial as it should be for the amount of time and cost involved. So there will be generally some documentary disclosure, but not masses in the usual course. Expert witnesses are usually required, particularly in the context of international trade, logistics, supply chain disputes, because there will always be an expert who will be required to set out the position, the losses, what has happened, perhaps some technical points that need to be addressed, and expert evidence as to who's liable, etc. And finally, following all of that, if the parties haven't settled in the interim, there will be what's called a final hearing, which is quite similar to trial. And at that, there will be opening submissions by both sides. Then witnesses will give evidence and be cross-examined. Experts will give evidence and be cross-examined. This all occurs before the arbitrator or the arbitrators, who will finally, a few months after the arbitration concludes, issue their award. And the award is binding on the parties. There are very limited avenues to appeal it.
You've just mentioned there the fact that there are multiple stages to the process and that it could be quite timely. Generally speaking, what sort of time scale are we looking at?
I mean, timescales vary hugely depending on the type of dispute in question. I mean, when you have an extremely complex dispute involving perhaps multiple parties in different capacities, or when you have a dispute that's extremely high value, the process can, just by virtue of the fact that it's more complex and worth more, take longer. But in a lower value dispute, a more simple dispute, it can be very quick. And it's hard really to say what the average is, because it will depend on how many witnesses are required. There may be more expert witnesses than just one if it's an extremely technical dispute. And those things can tend to cause the process to move a little slower because it involves more stages of the process. However, on the plus side, as I was alluding to, you generally don't have the volume of documentation that you do have in court proceedings, particularly in the UK, particularly in England and Wales, where disclosure is a massive part of any court proceedings, and it can take many, many, many months and huge amount of money and a huge amount of resource spent on reviewing all of these documents that ultimately may not come into play at all. So the documentary stage tends to be a lot shorter and faster moving. There are also expedited procedures for very simple or less complex disputes, where you can really, push those forward at a much faster rate. So I think, you can do it in months if it's an expedited procedure. It can take a year to 2 years if it's a more complex arbitration. But generally speaking, it should be a lot less unwieldy than the court processes, and a lot cheaper for parties if they do it correctly and reach agreement on all of the main stages.
And for those who are watching now and haven't considered this option beforehand, is it possible for them to add an arbitration agreement to an existing contract?
Yes, absolutely. I mean, it will depend on having the agreement of the counterparty to the contract. So, what you would do in this instance is contact whoever is the party on the other side that has control of the contractual relationship and indicate that you'd like to vary the contract to include an arbitration clause instead of a clause that would send any disputes to the national courts. I mean, the parties have to agree on this because arbitration, from its very core, is a consensual process. But assuming you can get the agreement of the other side and vary the contract in accordance with whatever the variation provisions are, so it's in writing, signed by the parties, etc., then yes, it's perfectly possible to change from a litigation from in the national courts to arbitration.
And when it comes to a multi-tiered dispute, can arbitration also form part of that resolution agreement?
Absolutely. And you regularly see that in the case of supply chain agreements, for example, because parties don't want to sort of press the red button and end up in a major dispute with the other side with whom they have to do business perhaps for many years into the future. And they may have different business streams going on with the same counterparty. So generally in these multi-tiered dispute resolution clauses, what you might see is the first level of the dispute will be a discussion perhaps between the CEOs or the general counsel or the manager involved in supply chain, logistics, whatever it might be. And those managers may speak and have 28 days to try to resolve their issues, or maybe a longer period. It then may go to a mediation, and a mediation, again, is not a court process. It's not an arbitration process. It's not binding unless the parties make it binding. And at a mediation, the parties can sit down and ventilate their issues with a mediator who tries to get them to reach agreement. And if that doesn't work, they can move to the next level, which can be arbitration or it can be litigation. So arbitration, you will often see multi-tiered dispute provision clauses in that regard.
Yeah, I think that's particularly relevant given the fact that the supply chain is multi-tiered. There are so many different stages involved. It's not A to B process.
Yeah, exactly. And the chain has to keep moving and things have to continue to happen, and parties don't want to suddenly cause a major issue in that supply chain.
Yeah, exactly. And moving on to the arbitration agreements, what should be included in those?
So, an arbitration agreement should always include whether the parties intend to have an arbitration as an ad hoc arbitration where they agree everything, or under some institutional rules, which, as I've said, are probably much more easy for parties because it sets out what you need to do and when, although it's all very flexible and the parties can agree to change the dates and times of all the steps involved. But that is the first thing that an arbitration agreement should set out, whether arbitration is intended under the rules of an institution. And I've mentioned a few to you in the context of international trade. One I see very regularly is the LMAA, which is the London Maritime Arbitrators Association. And I've arbitrated under their rules many times as well. The rules are very, very easy to understand, and as they are with all of the institutions, but the parties must put that in there. They must also put in how many arbitrators arbitrators. They would like to resolve their dispute, and generally that's either one as sole arbitrator or three for disputes that might be considered down the line that would be more complex or higher value. Then they should also say where the seat of the arbitration is. Now, the seat of the arbitration is a concept that might not be familiar to everyone, but what the seat means is the rules that will govern the procedure involved in case there are any issues. So if you say the seat of the arbitration shall be London, that means that the procedural rules will be those of the English Arbitration Act in the case of any problems or issues where the parties can't agree and the tribunal needs to go for the assistance of the courts. So the seat is extremely important and must be set out in the arbitration agreement. The parties should also set out the venue of any hearings, and the venue can be separate from the seat, which again is a very attractive feature of arbitration for international parties, because though they may want the English Arbitration Act to cover any issues that arise, as in the procedural side of things, they may not want to have the actual hearings in London. It might be handier for them to say Bucharest is the venue, or Paris, or to change where the parties actually meet in order to resolve the dispute. So those are the main points that need to be covered in any arbitration clause, and will make that clause valid and binding.
And finally, just to touch upon how the arbitration proceedings are regulated, what is the process at that stage?
So regulation of the proceedings is really in accordance with the rules in the first instance. And I should add that the parties can also choose the language, which again, for international parties is quite an important feature of international arbitration. But any of those rules or regulations are governed initially by the institutional rules that the parties have chosen, but also by the seat of that arbitration. So if there's an issue and perhaps one party thinks they don't consider that one of the arbitrators, they may consider them to be slightly biased in some way. What do they do in those instances? So what they would do is apply to the court of the seat of the arbitration in order to determine any issues that arise as to the actual arbitration's enforceability, etc. It's the courts of the seat that will govern ultimately if there are any issues. But otherwise, it's the rules of the institution itself. And the parties can always, for example, request assistance from the arbitral tribunal, or request assistance for the institution that they have chosen in order to run the arbitration.
Well, I think you've given us quite a good overview of what arbitration means and as an alternative to litigation. Do you have any final comments that you'd like to share with those watching who might not know much about this and who might also have issues with other parties that they are looking to resolve?
Sure. I mean, I think in the context of global events at the moment, all parties need to be thinking, who are involved in international trade, need to be thinking about what disputes could arise down the line and how they would want to resolve those and in what forum they'd want to resolve those. And I say that particularly in the context of the energy crisis that's occurred as a result of the Ukraine war. And in addition to that, the effects of climate change on the supply chain and on natural disasters. We're seeing it all the time, and parties need to be scanning the horizon for those types of risks and looking at their documentation to understand, well, what have we agreed to here if something goes wrong, if the other side can't fulfill their bargain? And do we want to litigate that in the courts of Hong Kong? Would we not prefer to arbitrate and have a neutral venue and a neutral seat of arbitration? And just thinking about their existing suite of contracts with international cross-border organizations, looking at them, carrying out an audit and saying, what do we want to change here to ensure that if there is a dispute, we can receive the treatment that we want to receive with an arbitrable tribunal that has the expertise to determine our dispute?
Okay, well, thank you very much, Aoife, for all of that insight. As I mentioned, it's been quite a useful overview.
Yes.
Thank you very much.
Thank you very much, Joseph, and please do contact me if you have any further questions.
We will. Thank you.